with lyrics on top that makes, and just to put it in context, I believe that Investigator Viverito said she collected off the internet a day or two after the Shamel Drinks shooting, and it says essentially I ride or roll with some real life killers. Right. Something I'm paraphrasing. And obviously that is, as they're saying, that Mr. Nichols was in the car next to Mr. Stillwell at the time that Mr. Drinks was shot. That's a big piece of evidence. That's not exactly how it appeared on the internet. And I'm going to go back to about a week ago, 2 weeks ago, where I kept saying we're on the 98-yard or we're on the 2-yard line. And I just have all these things that are dumped in this folder, and I don't know what they are. I don't know when they were collected. I don't know the circumstances.
Man, I'm so sick of how lazy some of y'all are. It's crazy. The state is literally handing out
that there was a collage on my story, which is a thing on Instagram. I'm not big on social media, but this is how it's been explained to me. There's my story. There was a collage of different, just different random thoughts, like Mr. Nichols is on a roller coaster. Mr. Nichols is saying that he's not feeling well. And it's just a bunch of different things that are kind of one after each other, lasts a minute and a half. Within that collage, I'm keep saying, there's a post where this song is playing, and Mr. Nichols is there, bobbing his head to it. It's Young Boy Never Broke Again, song is Villains. In the collage, and we can play it, it's a minute and a half. In the collage, there are lyrics from Young Boy Never Broke Again, that song, because when you put on Instagram, it displays the lyrics as the song plays. It appears to me that Mr. Nichols didn't choose those lyrics. He chose the lyrics directly afterwards. But before those are displayed, the I ride with some real killers or whatever is displayed for a millisecond. You'd have to rewind. You'd have to go through it and pause it at an exact point to even be able to read it. Okay, so and of course, Investigator Viverito doesn't write in the reports, so I had no concept that the still picture of I ride with some real killers and this collage were correlated in any way, or that one came from the other. So then we were doing the pretrial litigation about what we object to. I objected to the collage on relevance grounds and hearsay, and quite honestly, I didn't see what the relevance was because it was just the random thoughts of Mr. Nichols. And then I objected to the still photo based on hearsay. Prior to the litigation, I'm not suggesting that the state did this intentionally at all. They took out the collage before we litigated them. They took out the collage but kept in the still. So when it was time for us to litigate, the only thing that was in the folder, in the updated folder, was the still, and no one had made it clear to me that these two things were correlated. Mm-hmm. So then I argue against the admissibility of the still, saying it's hearsay, and Your Honor said no, it's a statement in furtherance of a conspiracy, so you let it in, but we never even talked about the collage anymore. So then we get to trial, and the state puts in the still with these very problematic lyrics just displayed without any context or explanation of how Investigator Viverito obtained that. Now, and here's the other thing. The collage was collected on the 10th, or excuse me, the 16th, 15th or 16th, the day or two after the Shamel Drinks murder. There's no indication from what I can tell that the individual pieces from the collage were not posted earlier. So the individual pieces from the collage may have been posted before the Shamel Drinks murder, which of course is, very relevant.
Experience Floor and Decor.
I was prepared to go up there and hammer these points home and say that Investigator Viverito selectively paused this and didn't provide any explanation to the jury, and I was going to go after it. The state and Mr. Abadi, and we've had discussions, and I can see from their perspective that they took it out based on my email, and they took out the collage video, and there was probably some miscommunication between the two sides about, again, I never even knew that they were correlated. So I do acknowledge, I do believe what they're saying, and they're saying, well, we kept it out because you objected to it.
Right.
So just like earlier in the trial where I put something into evidence that had a blank bubble for the date, and then it turned out, well, that was based on rulings. It wasn't me trying to deceive. I just want the truth out at this point. So my suggestion is I'm going to leave it alone on cross, and then the state on redirect, if they don't want me to go into it and create an impression, if that's what they want, I'll leave it alone on cross, and on redirect, they can have Investigator Viverito explain how this came to be and clear it up that it wasn't actually a post that looked like that, but it was part of a bigger post and all that. That's my proposal.
And that's fine, Your Honor. We can bring in. Of course you go. Okay. Sorry, we can bring in the video during our redirect of Investigator Viverito, and we'll bring in the entirety of and I want to be clear, Your Honor, this is, I know Mr. Shard is calling it a collage, but it is the Instagram stories that we've referenced multiple times, that these stores are only kept up for 24 hours. And so on the top of the video, you'll see 18 hours, 1 hour. That is how long the posts have been up. And at the time Investigator Viverito screenshotted or video recorded the video, the post would have been within 1 hour of her actual screen grab of the video. So for example, she screen grabbed this video on March 16, 2022 at 9:53:19 p.m. The specific video that we are talking about was posted 1 hour before. So it would have been posted around 8:53:19 p.m. on March 16th.
The story.
The story would have been posted.
Right. Do you have any way to know when the individual pieces of the story were originally posted?
So that is when it would have been posted, because they only run in 24-hour increments. So when it says 1 hour, the post had already only been up for 1 hour when she screen grabbed.
So the whole story, I understand you're saying, was posted within 24 hours of the screen grab. What about the individual pieces of it?
So it tells you. So
do you understand what I'm asking?
I am.
Okay.
Let me share with you, because I think it's better if I show you and then I can describe it for you.
The judge trying to play like she don't have no social media, like she don't know anything about social media. Somebody said she had a back page, allegedly. Not a back page, the fans only.
Are you able to see this, Your Honor?
Yeah.
I'm sick to my stomach at how lazy some of y'all are. I can't believe y'all be ignoring the state handing out $5,000 health spending cards that you can use on whatever y'all want. Y'all be letting these
It was on camera at the scene or there.
I ride or roll with some real life killers. Something I'm paraphrasing.
Because we're supposed to fill in the blank.
Your Honor, I don't think we need the knowledge charge. Or we, I should say, the state.
I mean, it kind of seems to pair with parties to a crime.
In RICO, if the jury believes that, I'm not saying that the evidence has shown this, but I don't know what the way the jury's gonna analyze the evidence, but if the jury believes that if they believe that Mr. Kendrick or Mr. Stillwell, had knowledge of an organization called YSL, but were not actively involved themselves, or not actively doing things in furtherance of the RICO organization, I believe that would apply.
Okay. Any others besides RICO?
Potentially,
If it's everything, I'll just say the crimes, that the defendants are charged with, but.
For instance, with the murder of Donovan Thomas, they've shown Mr. Kendrick at the Texaco, a video of who they say is Mr. Kendrick at the Texaco. I know it's a lot of debate whether he was actually in the Infinity or not, but I could see it applying there as well. Mr. Kendrick is quote unquote in the mix at the Texaco, but not actively participating in any crime that happens 5-10 minutes later.
Mm-hmm.
And I don't know how the jury is going to analyze Mr. Stillwell on Windsor Street, but obviously he's in the area, and obviously I'm going to be arguing that he was not the shooter. So I think that it would apply there as well.
All right. How about to the drug counts for Mr. Kendrick?
But, yeah, potentially there as well, Your Honor, if there's some theory that Mr. Kendrick had knowledge of the drugs and guns in Mr. Williams' house.
All right. The gun charge, is that based? He's got the one gun charge, right? Or does he have two?
Let me look at the indictment again. But there are multiple
57.
charges related to the guns.
Okay. So he's got
He
the.
has two.
Well,
He has 3 guns.
yeah, he has a bunch of gun charges. So
So his is based on, okay, the machine gun that's found during the raid, if you will. And then,
there's firearm during commission of a felony in 61.
right, but all of that is if they find him, if they find that he, was guilty of possession of the machine gun and the drugs, whatever, then he's also,
Right, that's like a foundational thing they have to initially
right.
find.
So I would think it would honestly even kind of apply to that, although I don't know. Like the firearm he's alleged to have possessed is the firearms that are found during the search?
Yes.
Is that right?
That's correct.
Okay.
Raise your hand if you think these boys should have took a plea deal too.
All right, so with regard to giving this as to the RICO count, I'm not sure it's an accurate statement of the law for what RICO is, because if you're found guilty, or you can be found guilty of conspiracy to violate RICO, even if you don't know exactly what your co-conspirators might do in furtherance of the RICO conspiracy.
But you do have to intentionally join in on
Yeah,
that
but
conspiracy.
we're going to give specific separate charges about, you have to, about what you have to know to be found guilty of RICO, but it's not, this is not exactly true for RICO.
Not for the individual acts, each individual act.
Right.
I agree with that.
The state agrees as well, Your Honor.
But they're, well,
So I mean, it certainly applies to the murder counts, I would think.
and the guns and the drugs as well, I believe.
And the drugs, the guns, it's really like if they're found guilty of, like for instance, with Mr. Kendrick, if he's found guilty of the drugs and the machine gun, then he's also guilty of possession of a firearm by a convicted felon. But if he's not found guilty of either of those things, then he can't be found guilty of possession of a firearm by a convicted felon.
Right, that would be an inconsistent verdict for sure if that happened, but, sorry.
Well, I don't-
Let me see.
For Mr. Kendrick, it's
It's all the weaponry. It's
it's all of the firearms that were in
yeah.
Mr. Williams' house. But is he charged separately with possession of those guns, or it's just that?
Just
Okay,
only
so,
thing charged separately is the machine gun.
okay, so, all right, then I guess if he's found guilty of possessing them, then he's found guilty of possessing them as a convicted felon.
So I'm trying to understand where the court has come out on whether that knowledge instruction applies to the gun and drug charges against Mr. Kendrick from what's at Williams' home.
I mean, there's the whole constructive possession.
Right, there is.
Law.
I understand that, and there's an instruction. I think there's an instruction on that.
There should be. If there's not, we need to put one in.
I believe there is, but there's an intentionality in the constructive
Yeah.
possession as well.
Why don't we put a pin in this one and come back to it? So I don't think it can apply to RICO. I do think it applies to murder. Gangs? I don't
Well,
think it could apply to gangs. They either,
the gang charge against Mr. Kendrick, let me make sure I'm saying this correctly. Oh, that's 57. It's count 57. It's based on the
possession
it's
of
based
the
on the drugs
guns
and the
and
guns.
the drugs.
Yes. Everything comes back. Everything is founded on the drugs and the guns, or based upon
Okay,
that.
so, right. I mean, the same for Mr. Stillwell. It's gang activity if he's found guilty of these crimes that would constitute gang predicates. Okay, so we'll just come back to that after we look at the kind of constructive possession charges. Okay. But it'll at least say, at the least, murder. All right, and so part of this knowledge charge includes a parenthetical that, you know, if you weren't knowingly and intentionally committing, participating, or helping in the commission of, or were not a conspirator in, then it would be your duty to acquit the defendant. So the state's certainly alleging that everybody is a conspirator in everything if they are in the RICO conspiracy.
And I think the court asked the question, we need to define it here.
Yeah.
I don't think you need to define it.
I think as long as we define it somewhere.
Yes.
Okay. All right, and then mere presence, everybody agrees. Mere association, everybody agrees. Multiple ways of committing a crime. It was requested by the state. Is there any opposition?
Well, we were talking about this on our call on Sunday. As I always understood this charge, it was like for aggravated assault, like 2 different ways you can commit assault and it's charged. I don't know.
We have it here in RICO because we've got RICO subsection A, conspiracy and RICO subsection B conspiracy. So I think that's the only place we have it. And so I would think this should come, you know, within the explanation of RICO. Does everybody agree that's the only place it is here? Okay.
Yes.
So we'll give this charge, but it'll be within the RICO. And let's just skip over RICO for now. So we'll have to come back to that. All right. Attempt.
Which page is that, Your Honor?
I'm page 24, 2.01.11. So y'all had mentioned at some point needing to give some sort of a charge on every charge, or, you know, a definition for every charge that is an overt act, but also a crime. Y'all still thinking that? Because I guess that's where attempt would fall.
Yes, Your Honor.
I don't see how else the jury makes the determinations of whether the overt or predicate acts were committed.
All right,
unless they
well,
have
I
the
don't think
definitions.
y'all, anybody has submitted what those charges should be. So y'all need to get those put together like today. All right, so attempt will go wherever attempt goes in the explanation of the various overt acts. Okay, down to 2.0210, conspiracy, and then conspiracy additional instructions. Everybody agrees on those. Conduct and presence of the party, everybody agrees. Okay, criminal gang activity. I have now.
Salute to Miss Irby in the building.
Made some suggestions. Y'all can see where things are rephrased. I don't think we have, on 2.0225, we don't have any allegation that anybody is employed by the alleged gang, right? It's just associated with, so I've stricken through employed by. Everybody okay with that?
Yes.
All right, and then instead of, everybody okay with commits a crime that constitutes criminal gang activity instead of the mumbo jumbo that is the pattern?
Yeah, I agree with the move to plain English there.
Okay.
Is that the highlighted portion?
So instead of participates in criminal gang activity through the commission of any criminal offense in the state of Georgia or any other state of the United States that constitutes criminal gang activity under OCGA 1615.3, just say, commits a crime that constitutes criminal gang activity, since we're going to define that in a minute anyway. All right, and then next thing we do is criminal gang activity means. The commission, attempted commission, conspiracy to commit, and then there are also possibilities for solicitation, coercion, or intimidation of another to commit. Do we have that solicitation, coercion, or intimidation alleged in this case? Okay, so I'm striking that. And then are y'all all right with the way that it's proposed there to just do kind of bullet points of to prove a violation of subsection A is alleged in 50 and 57?
Yes, Your Honor.
All right, and then element 4 would be a nexus between that crime and the gang. I'm not sure. Most people might know what nexus means, but it's not like a word everybody uses. So I would kind of think it would be more helpful to the jury to include a little bit more than that. So what I did some research and found in 2 cases, Dixon and Rooks, where nexus was explained to be a connection between the crime committed and the gang, which we could say that way, or a nexus, a connection. We could also add that the crime was committed to further the interest of the gang. Now,
So in layman terms, nexus is a conspiracy of a conspiracy.
Mr. Weinstein, I noticed that you had objected to the pattern on that, which, okay, I'm sorry.
I was taking
Mr.
notes
Shart,
for both of us. Your Honor.
the pattern says a nexus between the crime committed and the gang, that the crime was committed to further the interests of the gang, meaning proof that the crime committed was the sort of crime that the gang does. Are you just objecting to that last clause, or also that the crime was committed to further the interests of the gang?
I'm objecting to the last clause.
I couldn't find it anywhere in the case law that that's what it
Okay.
meant, so I agree with you, that should not be pattern.
So we're going to strike was the sort of crime that
Well,
the gang does, Your Honor?
Yeah, so the choice at this point is a nexus between that crime and the gang. I could say a nexus that is a connection between that crime and the gang, or I could just say, or a nexus that is a connection between the crime and the gang. In other words, that the crime was committed, or that the crime was committed to further the interests of the gang. I mean, like, basically any of those, any combination of those, what is the preference of the parties?
Can we write this? So
It's in front of you. It's on the bottom of page 29. If you have the electronic copy up that Ms. Persefield sent y'all
The language,
yesterday morning.
the language you have now is a nexus, comma, that is a connection, comma, between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Yeah, that's just some language I pulled from Dixon and Rooks explaining what nexus meant. So I'm just saying we could use any of that and it would be.
That language is acceptable to
Okay,
Mr.
so
Kendrick.
you want me to just say it all?
Just exactly like it's written is
Okay,
fine with Mr.
so
Kendrick.
I'll just bullet point or whatever, element 5 will now be that. All right.
Yes, Your Honor.
yes.
Okay, you got it, Laura. Okay. All right. Definition of participate, I'm kind of thinking, unless somebody on the jury says, what does it mean by participate, that they know what it means by participate. Okay.
Yes.
All right, and then criminals, definition of criminals, street gang. Are y'all okay with?
All right, let me bring y'all up to speed real quick. Now, all the guys that went home. Nobody left but these two. We got Deomonte, Kendricks right here, right? And Shannon Stillwell. Everybody else took a plea that was in the courtroom. And before that, the rest of the co-conspirators, well, not co-conspirators, co-defendants, they had previously took their plea. These the only two boys that's going to take it to trial. And I kind of feel sorry for them because everything they wanted to hand to the rest of the gang, if they found guilty, they're going to hand it right down to them. So right now what they trying to get these two boys on is a conspiracy of an M1, right? And I know everybody lost because of the way the state go about they cross examinations or whatever. Now the trial trial for the day hasn't even started. They still going over preliminaries, which I don't understand why this occur every day. This is something that should have been done prior to the case even starting. I.e., that's why I say the state been building their case as they go along. They still bringing in evidence that these boys putting up on social media today. Now, that in itself, I think that shouldn't be allowed, because if you had a case to bring them to trial, all the evidence should have been presented before the trial started. That's why the defense and the state keep going back and forth, because the state, we gonna say, what's her name? Miss Love, allegedly, kept presenting evidence that she hadn't presented to the defense. How can they defend themselves if they don't know what the charges that's being brought against them? Anyway, and Vaughn, I see you say you lost. Nah, you gonna be lost the way that, like I said, the way the state presented their cross-examination and trying to bring this trial, this case, present this case to the jury. The jury, I'm sure the jury's sitting over that law. Notes got to be up to her to where they just said, forget it, man. I ain't writing no more notes. I'm lost. But I'm gonna stop my jaw jacking, man. We gonna jump back in here, and we gonna try to follow along. If not, y'all know it's a movie being made. The script is being written as we speak. So this trial here, I'm doing it so we can come back and reference the characters that they put in the movie. I missed day 162. Don't worry about that. Don't worry about none of the days that this gonna be a full volume of this trial for the entire year. But like I say, we gonna keep it moving.
The strike throughs. And I can say it all, but
I'm fine with, the state's fine with strike through.
okay.
Yeah, I'm okay.
So can you see it on his?
Your Honor, could you tell me the page again?
Page 30, bottom of page 30, definition of criminal street gang.
I think.
Okay, well, so
Going on?
the
Okay.
criminal street gang means this is the pattern: organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal activity. And I'm suggesting that the same concept is conveyed by saying criminal street gang means any group of 3 or more persons associated together, which is engaged in criminal gang activity.
Okay. It's just formatted different on my page,
Okay,
but it's the
sorry.
same thing. No, it's okay, Your Honor. I'm fine with that change.
Can I just make one request?
Yeah.
Which engages in criminal gang activity, which is
Uh,
already been defined for you. Because I don't want the jury.
Criminal
to
gang
take
activity as defined, have I already defined it by then? Yes.
In 25.
Sure, as defined.
To take a layman's view of what.
As I just defined. Can you stick that in there? All right.
Or maybe as defined in 225 to be more specific. But
No, because they're not going to have those numbers when they
okay,
get the
that's right.
instructions. They won't have the headings. They'll just have the law.
Thank you.
And then, it'll continue with the existence of the gang maybe established by. And then the pattern suggests, as charged in this case, criminal gang activity is, and then I'm supposed to list the crimes in the indictment that would constitute criminal gang activity, although I would only do the ones that they're alleged. So it would be whatever's set forth in, I guess, 50, 51, and 57, right?
Yes.
So, as charged in this case, criminal gang activity, I think as charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. 'Cause I think you're getting into
So
those
that would be
definitions.
murder, and 57. So it would be murder, and then everything listed in count 57. Possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So, question here. Do you want me to say murder charged in counts whatever, or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence?
No.
Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation, y'all are in agreement, motive, agreement. Possession of a firearm during the commission of a felony. Y'all said you're going to tailor it. Let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged it both ways.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply?
Yes, Your Honor.
Right.
Okay. And then the drug stuff, as I so aptly put it, would be possession or possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute. possession of marijuana or codeine with intent to distribute, or possession of cocaine?
Yes.
All right.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing a felony, which is a crime involving another person or a crime involving possession with intent to distribute or possession of those particular drugs, and then say, I charge you that certain of those drugs are a controlled substance, or just say, just get to the heart of the matter, which is if you find he did these things, then that would be possession of a firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs?
I think the latter, Your Honor, is
Yeah,
cleaner.
it is
Yes,
cleaner.
I think so
It's
too.
simpler.
Everybody agrees?
Yeah, I agree with Ms.
Okay. So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No.
Not for these two counts.
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count for the two counts, count 63 and count 52, while we did charge 133,
Yeah.
it is missing an element. And-
It's missing the indictment is missing an element?
Yes, Your Honor.
That was going to be subject to the motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 132.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence that's established has the elements
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you law, Your Honor.
So either it's going to be, in my view, 133 or nothing, unless y'all have law to change my mind. But assuming it's 133, I think it's possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm. But we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all dropped the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like, the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. Tell Laura, just write me a note to rewrite it like the other ones are. Okay. 2.70.10. Y'all agree? So it's possession, right, of marijuana or no, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay. So it's possession of cocaine. The state must prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the state must prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance. It would say to distribute codeine, which is a controlled substance.
Yes.
Yes.
Hey, Ryan, can we, I'm sorry, I was typing, can we go back to possession of machine?
Yes.
If you did not say, and I apologize if you did, I think we need to define machine gun, which would be 1611-121.
Let me see what 1611-121 says. Does it give me a definition of?
Yes, it does, Your Honor.
Well, that's very helpful. And obviously, I'll let y'all look at it again after. We put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611-121. It's part of element 1.
Open my code section, got it, Judge.
Yeah. And then definition of marijuana. Everybody's good with that. Did we have testimony that whatever was found was marijuana?
I don't believe y'all introduced any of the lab reports, did you?
Detective Storno testified that it was marijuana. Now, there's no lab test, that is correct.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor. I apologize for not, the GBI analyst who testified about all the pills. She also talked about she tested the marijuana.
Okay.
Okay.
So, state must prove that defendant possessed the marijuana, controlled substance, or gun, right? Or gun at issue in this case.
I'm sorry, could you give that list again, Your Honor?
I mean, I would think it would be the marijuana, I can just say codeine, cocaine, and guns, firearms, because it's a machine gun too, guns.
Yeah, firearms. There's a half a dozen, roughly, so.
Okay, on equal access. I would think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
I mean, I'm fine with just possess, Your Honor, but.
All right, well, since it's your client that's facing those charges, although not with the guns, just possess and not put the items where they were found. That's an interesting one.
Well, I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting. Or possessing, but that's neither here nor there.
If moving down to 27630, if you find that the defendant owned or leased where would
What's the second
Mr.
paragraph?
Kendricks is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio? Yes, no?
No.
What did I say?
Stillwell
Is it the reverse of that?
yeah, he's not charged with it.
Isn't he charged with possession of possession of a firearm is if he committed the murder with a firearm.
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 27630 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know if
It may not even be applicable.
Well, I think it would be. I'll let Mr.
No. I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that.
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it or I can just not read that because it's not applicable.
Yeah, okay, now I see what you're saying. Your
We
Honor.
could just say,
Yeah, I've read it. So it probably isn't.
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
Yeah.
where all of that
guns.
stuff was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You may.
Okay,
I don't object
so
to
we
it being
won't get
removed
that
then.
one at all. All right, affirmative defenses. The note is Defense believes this must remain. So I need some evidence
Go, Max.
to,
Mr. Stillwell keeps trying to trip me. So,
He has no proof of that.
Your Honor, I am taking a stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge. We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself. People are shooting at Woody. It's okay if he has a gun. And my stance is that we've heard testimony that people are repeatedly trying to murder Mr. Stillwell. Mr. Stillwell is charged with possession of that FN 5.7, and he's charged with that. And our stance is, while it doesn't, it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated
and
in
can
this
you
charge.
give me a second to find where that's his count, what, 52?
52 and 64.
No, he's not even, 52 and 64?
Yes, Your Honor.
Well, 52, 54, that one doesn't charge, that just is the murder. 64.
It really applies, if he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be, fall under instances of reason and justice. But for 64, when it's the standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you need to...
Hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the Drinks murder, right?
Yes.
Count 64 charges he possessed a gun on the 17th of March.
Yes. And that was on Meadowlark Drive. The
When
gun
he
that
was arrested?
Right. The gun that the state is saying was thrown out the car.
Oh, which you've...
Registered to Miss Alexander.
Okay.
And my argument is, if the jury finds that Mr. Stillwell was in fact carrying that gun around, and either he or Mr. Nichols discarded it out the window, 30110F would apply, and the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that F is a reference to A through E. So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you know what? You're right, Your Honor. I'm sorry. You're right. It would just be.
Okay, but here's the thing with the law is that if he had been possessing a gun despite being a convicted felon and somebody came up to his window and held up a gun to his temple and said, you know, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. Do you know what I'm saying? Because it's a specific reference to 16:3, 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's a Johnson case. It's the one that the Hogues argued, and was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense, even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. The difference that here, from my perspective, is the person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun. Then something unexpected happens and they use the gun.
Okay,
My
well,
scenario-
he knows somebody's after him.
Right,
Do
that's
you
the
have any
difference.
case law to support
There
your
is no
argument?
case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that. I mean, especially if Johnson is a case that says, if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is, in fact, what Johnson says, to
Okay,
my understanding.
Well, I mean, unfortunately, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life, you know, can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's just not what the law is.
Of course, I'm going with the court, and I respect the court. I would argue that that's what F is. That's why F is there. Because it says, in all instances based on similar reason and justice. And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good
you.
legal argument. It's clever. State want to be heard?
That's just, it's frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before and knowing that he had it after if he left with a gun, but he could be found immune from possessing the gun during the alleged whatever act he was unjustified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right. I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Shannon.
All right. So we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all candor to the court, then we probably don't need 30000.
Okay. Or 31010.
Correct.
All right. And we clearly don't need 31011 because it doesn't even exist anymore.
I don't think we need any of these
All right.
justification.
I don't either, because they all are like basically if they're, so no 1, 2 and no 1, 3. All right, then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for RICO, y'all are both in agreement that the one that's listed is fine?
Yes, Your Honor.
Okay. Venue for conspiracy to commit a crime. Other than RICO, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So, do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms for 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want that at all. Because I believe that is, I think that's covered in the next.
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
Yeah, I don't believe that this is necessary.
Okay.
And I'm sorry, Your Honor, which part is not necessary?
1.60.12. Do we need that? It's way too hot in here.
The state over there scrambling
defense
through them
is
papers
no
right
longer
now like I
requesting
used
it
to
if
be
they
in high
ever did.
school when the teacher called my name.
Is the state
don't know
still
where we
requesting
at.
that?
You said 1.60.12, correct?
Yeah.
Multiple defendants.
Right. Given that we're given the charge below about assessing the evidence against each defendant that the state requested.
Yeah, we don't need 1.6.
All right. All right, assessing the evidence.
There's 3 charges been thrown
It
out.
appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it.
Yes, Your Honor.
Okay. Court has no interest, no sympathy. Sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely to be a conviction coming from the court.
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is, that's typically what the request.
People think they know what the penalty is.
Well, right, but I guess because the people think they may know what the sentencing range is or what the penalty is, which is a life sentence. A lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making, which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that for them to then think about. All right, and nobody has any issue with deliberations or unanimous verdict. State, there's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it, okay.
It can be argued, but it can't.
Okay,
Of course not do a charge on it unless the defense requests it.
all right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah, page 14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think?
Look at them. We don't know what to think, Your Honor.
Anyway.
Our preference would still be to keep that knowledge charge in, especially, I understand that
I'm asking which crimes do I say it applies to?
the murder, the drugs, and the guns. Did I leave anything out?
Say D, all of the above.
No, I left out the RICO.
And, the RICO.
And the gang, which
Well, the gang is,
it wouldn't even make sense for the gang.
no, so the murder, the drugs, and the
Okay,
guns.
so knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count whatever, possession of whatever it was, drugs in count whatever. Do y'all think? Was being committed, and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed, or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there, because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of, list them again, and that the defendant knowingly helped or participated, then you would be authorized to convict the defendant of that count, I'm going to add that.
Yes,
Okay.
thank you.
All right, anything else we said we were coming back to? Obviously RICO, but anything else?
I sent a proposed charge to Ms. Percifield and counsel as it relates to count 51. Mr. Stillwell is charged with 1615-4 subsection B. And I sent a proposed charge as it relates to to that count. It's not covered by the pattern.
That being gang,
So the pattern covers 1615-4A, but it doesn't cover B.
isn't that in our gang? It's, if you look at what's there,
It's already in here.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus, in order to, there's an additional element, number 4, in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right?
I completely.
Okay, it's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes.
Thank you.
We've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anyway. So yes, you can have until they get here.
Thank you.
You tell me they've been in there all that time and the jury still ain't there yet. Now you got to pay attention to how. See, I'm looking at the judge's character too. How she act with the state. How she act with every time the defense comes with an argument. She gets an attitude. But for the most part, she's nice to the state. And she's helping them with their case.
I gave Paul that mic that's got the red on. Was those my glasses? Those my glasses. Yeah.
Fine, and she been helping it. She been helping the state since she been in the building. Like they try to get her to recuse herself, just like the last judge, but she been refusing. She been refusing every mistrial that they done brought, just like the last judge. I don't like this judge. I don't like her at all. She's just supposed to be the mediator. To me, she's choosing sides.
Thank you. Everybody can be seated. Go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good morning. Good morning.
Good morning.
Investigator Viverito.
Good morning.
Are both those mics being used?
This one is.
Oh, it's fixed.
Yeah.
Okay. All right. Thank you. So, Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
Correct.
Okay. We are going to get back to that later.
Sure.
Okay. So we're going to switch to another topic right now. But it is about the posts from March 2022 that you collected.
Okay.
Okay. The reality is in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
Correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' death as
Correct.
well, correct? Okay, and let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Okay. Investigator Viverito, this is a post posted by one ABG_Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected, would have been around 8:20 on March 11th.
March 11th. Okay. So this is the morning after Christian McMiller and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay, the evening after.
Correct.
About 20 hours after, 21 hours, or 19 hours after.
Somewhere around there.
Okay. And this post includes says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMiller being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he is associated with Atlanta Blood Gang.
He's documented as a member, and he's also a fixture at 12 Atlanta daily.
Okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for
Correct.
the murders of Christian McMiller and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we'd take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation involving Mr. Drinks when I get to it, okay? But I'm asking you specifically about posts. Posts is not a confession to killing Darius Ford or Christian McMiller, is it?
Absolutely not. But as an investigator, you need to look at things as a whole to piece things together, leading you towards suspects.
Okay, and that's why you collected this?
Correct.
Okay. Ms. Knight, I'm going to ask you to publish 462 VV. Okay. 462 VV is two posts that showed up on this page labeled Joey_Hurst 24, correct?
Correct.
All right, and on the left is Christian McMiller,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMiller and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMiller and Darius Ford?
Yes.
Okay. Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page, yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was,
No.
the government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is you did not view these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay. 456 VV. Please, Ms. Knight. Thank you. Okay, and this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct.
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought new op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason, again, is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay.
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
He has not.
Okay. And this has all happened 2 years ago at
Correct.
this point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me?
Sure about to get in her shit.
Okay. In 473 VV, that's posted by Shell Kel Nutlife, correct?
Correct.
And you know that to be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think, in days following.
Okay, Ms. Knight, could you please publish 461 VV? Okay, and here's another picture of Shell Kel or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct.
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's 2 little shells under his left eye.
Correct.
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct.
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed, yes.
And this is on Shell Kelvin Watts' page.
Yes.
And again, we see the 2 shells.
Correct.
Okay, and that had significance to you because there was 2 dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
And we have 2 shells, right?
Correct.
And we have a smiley face, except the lips are zip-tied or zipped up, I guess.
Correct.
And a black heart.
Correct.
Okay, and this was on Mr. Kelvin Watts' page.
Correct.
All right. Also, and Ms. Knight, thank you. Also, you're aware that Shell Kel or Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Kel and Third World?
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to 2 snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast car is the Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Speculation.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
They were in a gray and color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me. So
Okay. That's fine.
But
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still an open active investigation.
Right. And you've had you collected these postings that Mr. Watts made way back in March of 2022.
Correct. But so an investigation's just the social media posts aren't enough to arrive at probable cause. You'd need him maybe on video at the crime scene before that murder, things of that nature. So if the social media was enough for probable cause, a lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene or there, or there was no knife.
Agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras. I promise you.
Commentary and.
Well, there's commentary going on both sides.
Get in her shit, short.
Okay, I want to clean up some. We're going to shift off of social media, and we're going to get to the wiretaps. Okay, I want to clear up some issues, or not issues. I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. I'm talking about Demekion Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair
Probably
to
in
say?
the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct.
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay, because that would defeat the purpose of the wiretap,
Correct.
right? And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes.
Okay. So it wasn't a random sampling, it was calls that the state chose to focus on.
It's my understanding that the prosecution and the defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the case.
Right. Yeah, right. I'm just saying it just wasn't some random sampling.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. when you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
He was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demekion Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about Demekion Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He
at
was
the
in
time.
custody. So he wasn't involved with any of those things that Demekion was talking about, running into Blizzy in Cobb County.
Correct.
All right. And then we also heard a call between, I believe, Demekion Garlington and Antonio Sumlin, and it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekion Garlington and a gentleman named DeMarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many, 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay. Now, based on your investigation, you said Boyer was at the gas station.
Correct.
And you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing it on the fact that Miles Farley, in that video, when he goes back to the car, gets into the back seat at the BP.
That, and there are calls from the wire that
Okay.
say that he's in the car, yes.
Fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi.
Correct.
And Mr. Boyer, who is not charged in
Correct.
this case, is a passenger in Mr. Nichols' Ford Fusion.
Correct.
Okay, white Ford Fusion.
Correct.
Okay. Your investigation, based on the time on the surveillance video from the FedEx surveillance, is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off shortly thereafter. Within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made where eventually Garlington tells Boyer to go to video, that 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time,
Correct.
right? Okay, so that's based on the wiretap time. Okay. So, and then of course, after they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through.
Okay, and do you know how long that call was or when exactly when it took place?
Immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct?
we have the FedEx video time,
Correct?
and we have a BP video time.
Correct?
Okay. Are any of those, to your knowledge, are any of those three separate surveillance systems synced up?
They're not. So typically what you would have to do is go back and sync them, because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I'd have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data.
Right, exactly.
Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when this call was made, because those two timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay, and the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those two cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap time?
Correct.
Awesome. Okay. Mr. Atkins or Ms. Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask some questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes. Okay. So, we listened to another call at 2:01 a.m. between, do you know who that call was between?
I'd have to hear it.
Okay, well, I'm going to cut to the chase. You said in court that you heard someone say, riding by the scene.
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said, but you said the scene.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you, and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish.
This is 350.
Right, and whatever Yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? Nah, the nigga Ray got it, not Dan still got it.
Okay, could you pause it?
Oh, for real?
All right, now, Miss Investigator Riverito, do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was kind of muffled.
That's fair. All right, Miss Hilton, if you could. Yep.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his change? That who changed Lil J5 to Jason? Oh, for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh yeah, I had Lil J5 with me last night. That's probably what it was. Yeah, okay. Yeah, that who changed it.
All right, so check this out, squad. First and foremost, I must say, salute to the squad. I appreciate y'all rocking with me tonight. If you have not subscribed, go ahead and subscribe now and hit that notification bell for part 2. We're going to pick this up tomorrow, maybe around 4:35 p.m. Central East and West Central Standard Time. And on that note, I am Mr. Follow Up. This is Fly High Productions. And I'm out. Squad up.